I think you want to do that, don't
I did.
you?
We'll go ahead and call the meeting to order. The clerk, please call the roll.
Calling the roll, Mr. Jones.
Here.
Mr. Rogers. Ms. Simon. Ms. Conley. Mr. Miller. Mr. Brady.
Here.
Mr. Germana.
Here.
Mr. Gallagher.
Here.
Mr. Schron.
Here.
Ms. Conwell. And Mr. Greenspan.
Here.
Everyone is accounted for.
Great, thank you. And I thank my colleagues for coming today to this meeting, as well as thank them in advance for for attending the meetings that we will be holding over the next few days to go over the charter review recommendations out of the Charter Review Commission. I want to briefly go over and explain the protocol and how we're going to be addressing these issues. And the rules for this activity are different than the rules in which we engaged a year or so ago when we discussed charter amendments, proposed charter amendments that were crafted by council and by the administration, by the courts, and other bodies that presented proposed charter amendments to us. And I want to explain a little bit about how we're going to operate today. So the purpose for us being here, obviously, is we know the charter mandates that within the first 2 years, a Charter Review Commission is paneled, which they were, and we voted on that, on their appointments. And they are returned back to us by July 1st, which they did, recommended charter amendments. Now, what's unique and different about this process is that the proposals that they're bringing back are submitted in the form of a report, which you have in front of you. They have not yet been presented in the form of legislation. That will be brought forward before us this evening. So in reviewing the calendar and the time frame that we have between now and the Board of Elections deadline of the first week in September, in order to meet and get these items on the agenda, if it's the vote of this committee and then of council, would be to meet as we're meeting now. I mentioned the uniqueness of this. We cannot, these items that we're going to be hearing today and then we presented for vote starting tomorrow, we cannot amend in any way. We either make a recommendation from this committee of the whole to council to refer them to the ballot, or to refer that they will not be placed on the ballot, and that is it. So the process is a little different. If, however, there is an item that we wish to, any council member wishes to amend, that will have to be done and presented as a separate resolution and provided to the clerk by July 16th for its first reading on July 23rd in order for us to meet the deadline, as I said, of September 6th. And you have that proposed timeline in front of you, and just to go over it briefly, we're meeting today, Committee of the Whole, and the process will be, after I am done with my discussion here, Chairman Akers, Chairman of the Charter Review Commission, will come and give a 15-minute or so discussion on the workings of the Charter Review Commission, an overview of what they've done. And at that time, if you would introduce the members of the commission that are here. Then we'll have a member of the law department will read the title and the rationale behind each of the 15 charter proposals, as well as the 6 items that were in the minority report, that made up the minority report. I don't envision there being much discussion, if any discussion today on any of these items. It's just an introduction as to what is being presented. We will then meet tomorrow at 1 p.m. and we will then begin reviewing each of the items in more detail, and we will begin voting at the end of the presentation of each item whether to refer it to council with a recommendation to be placed on the ballot, or with the recommendation that not be placed on the ballot. Once again, no amendments can be made to those documents. We will continue down that protocol until we address all 15. It's my expectation that we should be able to get through those within the next 2 days in order to stay on our timeline. With that being said, I will then, let me just continue and kind of review a little more regarding the process. In order for an item to be placed on the ballot, now in order for an item to come out of this committee, it will only require 6 votes. But in order for an item to be placed on the ballot, it will require 8 votes of council. So I want to make sure everybody's aware of that. And with that, I have no other comments, and I'll turn it over to Chairman Akers for his comments.
Thank you, Chairman Greenspan, President Connolly, Vice President Simon, distinguished members of the council. On behalf of all my fellow Charter Review members, we thank you for the privilege of having served on this commission. It has been an honor for all of us to have helped in hopefully some small effort to further strengthen this new charter. I do wish to, as the chairman requested, introduce, not everybody could be here today, but those that are here that I'm introduced, and I will do this so as not to offend anybody in alphabetical order. First, Nancy Dietz, civic activist and former Cleveland Heights councilwoman. Maisha Wilson-Hedden, an accountant, a council at large, Richmond Heights, and a professor of business at Tri-C. And then, one came in here. Patrick McLaughlin, head of McLaughlin Law, and a former U.S. attorney of District of Northern Ohio. And then Davida Russell, who is an active labor leader. I can't remember all of those initials of the local 4 that is served with me as vice chair. Did I miss anybody? Okay, we know one more is coming. These past 9 months, we have worked well together, the 9 of us. We've held different points of view on various issues, but no one came to this commission with preconceived, hard and fast opinions or thoughts on it. Each has been respectful of the other's points of view and in sharing thoughts and suggestions, and this has led to a very healthy series of discussions. The commission has been comprised, as you can see there in the report, of very interesting, hardworking, dedicated citizens with a wide array of backgrounds, and I, as a personal note, would say that I've been very honored to serve as their chair. During these past 9 months, we have held 26 meetings. We've interviewed, met with over 40 public officials and concerned citizens, and have held 4 public meetings, east side, west side, south side, and downtown. Out of courtesy and respect, our first meetings were with the county executive and the members of council. We looked at, discussed, and received testimony, recommendations, comments on 31 subjects or issues. We also received from Sister Joanna a copy of the council's report for the charter issues that you studied last year. We have elected to make recommendations on 15 issues. Also, there are 6 minority reports attached. On the one hand, we wanted to help improve, clarify the 2-year-old charter where needed. On the other hand, we were concerned about making recommendations on too many issues and thereby conceivably causing voter confusion with so many amendments on the ballot. That is why we concentrated our recommendations on the 15 issues that we felt needed the most attention at this time, and why we elected to defer our recommendations on 9 other issues. I want to say at this time that those who drew up the charter originally sought to have as good and as solid and as comprehensive a charter as possible. We studied the Summit County Akron charter and the Allegheny County Pittsburgh charters, but hard as we tried, we knew that it wouldn't be perfect. Therefore, we deliberately inserted into the charter the provision that after only 2 years, a charter review commission would be set up to see where changes, modifications were needed. We knew that we knew that the best example and test of the effectiveness of this charter were those who had to work and live under it, namely the county executive, the county council, and county staff. We 9 members of the Charter Review Commission have sought to fulfill that charter directive, and hopefully you will feel the same way. Therefore, after much deliberation, we elected, as I say, to come up with 15 recommendations, and we respectfully urge the members of County Council, after, of course, due deliberation, to favorably act on them, and in turn, to urge the voters of Cuyahoga County to support them in order to further strengthen this great charter to better serve the citizens of Cuyahoga County in the many years to come. Specifically, we concur that on executive appointments, council should have 60 days rather than 30 days for council confirmation. We concur that some 10 action items which pertain only to and only impact on council should not require executive approval. We clarified the interim appointments of department heads that they may serve for a set period of time without council confirmation, but for a period not to exceed 120 days. We clarified the issue of a council incumbent who, after the decennial redistricting process, no longer residing in the district from which that councilman was originally elected. We established the same residency requirements for the county executive that is already in the charter for the members of council. We sought to clarify the language for the timing of an election following the fulfilling of a vacancy on the council. We endeavored to clarify the charter language regarding the Board of Revision, whereby there is to be only one Board of Revision, not plural as presently worded, and that the Board of Revision, in turn, will appoint as many 3-member hearing panels as are needed, and further, that the hearing panel members are not full-time county employees. We clarified the confusion between the Human Resource Commission and the Department of Human Resources. First, by recommending a change in the commission's name to the Personnel Review Commission, and then to distinguish the duties of the Director of the Department of Human Resources from that of the Personnel Review Commission. We concurred with the county prosecutor in recommending the establishment of a performance audit of the county's judicial system, specifically to be conducted every 5 years. We strongly recommend not only the continuation of the Office of Inspector General, but establishing it as a formal part of the charter. Looking long range, we urge this step so as to avoid the possibility sometime down the road of an executive and a council which, for whatever political reasons, might choose to curtail or even gut the current Inspector General ordinance. After much discussion on campaign finance reform, we elected to recommend that council not only has the power, but also should have the duty to enact campaign finance law, rather than our recommending specific finance limits. And we recommend a change in the matter of executive succession. On 3 other issues, there was considerable discussion and difference of opinion. In each of these 3 issues, the Charter Review Commission is recommending changes or clarifications, but not the significant or total change as recommended or urged by some proponents. Specifically, on the matter of the sheriff, we recommend retaining that position as appointed by the executive and confirmed by council, rather than it reverting back to being an elected position as it was in the past. However, the Charter Review Commission believes the independence of the sheriff's position is essential. Therefore, we recommend that the independence of the sheriff is further provided by having a staggered term of 4 years from that of the executive, and further, that a sheriff can be discharged only with the approval of 2/3 of the members of council. There is a minority report on that matter in your report. Secondly, on the matter of the clerk of courts, the Charter Review Commission recommends retaining that position as appointed by the executive and confirmed by council, rather than the clerk being appointed by the presiding judges. However, we recommend the county executive solicit the advice of the administrative judges for his or her consideration in making that appointment. Again, a minority report is included. And thirdly, on the allocation of legal duties between the county prosecutor and the director of law, we have spelled out 5 specific duties for the law director, However, a majority of the Charter Review Commission did not endorse the wishes of the executive branch that the law director represent the county in all civil litigation. Again, a minority report is included. Therefore, members of council, we render you our report of recommendations and stand ready to be of any help, whatever we can be in your deliberations, and decide to what you decide to send to the voters in the November election. On behalf of my colleagues on the Charter Review Commission, we thank you very much. Mr. Chairman, you want me to say here?
Yeah, just for a moment, you have another member that showed up while you were speaking.
I'm sorry. Another member is William Tarter, the president of the Young Professional Senate. We have 5 here today.
Great. Well, thank you. And I believe I speak on behalf of the committee. I want to thank them for your service and for preparing this report. Mayor Akers, I appreciate you coming up from your 50th wedding anniversary trip.
15th. Thank you. I appreciate your comment. No, my wife and I, we both are second marriage. We both lost our first spouses, and this is our 15th wedding anniversary.
Okay.
So we brought planning way before you set this meeting. We are bringing all families in, Seattle, Houston, Detroit, and those in Cleveland. And we took some cottages out at Maumee Bay Park for a week. And so when I heard you said this election set this time, I got somewhat divided on it. I appreciate, though, your mentioning that.
And give your family my apologies.
Okay. Well, and if you don't mind, having said that, since you brought it up, I will be back tomorrow, but I hope you will not. I will not be in bad trouble because I don't show up on Thursday.
Very good. Thank you. Yeah, Mr. Miller.
Mr. Chairman and my colleagues and members of the commission, I spent a lot of time attending the meetings of the Review Commission, and I just want to speak for a minute about the amount of time that was spent, the amount of dedication that the long weekday nights, the long Saturday mornings, the number of meetings. It truly was a labor of love and a real dedication to the county, and the commission also represented a diversity of very astute views, which got collected into this report. So I just want to thank you very much for a job very well performed, and urge my colleagues to take the recommendations very seriously. Thank you.
Very good. Thank you. I also want to thank Mr. Boyle for his time and attendance and attending the meetings. I see he stepped away, so if... there he is. Thank you. So I want to thank you, Mr. Boyle, for your dedication. Before we have the presentation from the law director, and Mr. Mayor Akers mentioned the fact that he will not be in attendance on Thursday, but asked that a few items be discussed tomorrow while he will be here. And so we will move items 9 and 14, which very well may be heard on Thursday, to Wednesday's agenda. And what we'll do is lead with number 9, then go to 14, number 3, and number 4. We will move numbers 1 and 2 to be after, to be the 5th. Number 1 will be the 5th item tomorrow on tomorrow's agenda. With that said, I'll turn it over to, oh, I'm sorry. Well, Mayor Akers.
Additional member of the commission, Sean Riley, the managing partner of the Cleveland office for McDonald Hopkins, also the mayor of the village of Gates Mills.
Great. Well, thank you and welcome.
Thank you, Mr. Chairman. Before I begin, I would also like to thank all of the members of the Charter Review Commission, the time and effort they spent putting together these recommendations, and the diligence, the thoughtfulness, the careful consideration, and the collegiality, thanks to Chairman Akers, was really above and beyond. and I just want to thank them for their service to the county. So basically what I'm going to do here is go through each of the individual proposals and provide a brief explanation of the intent of each one and a brief rationale. So with the council's permission, I will begin. Amendment 1 deals with proposed changes to the executive's appointment authority in section 2.03 of the charter, and there are 3 specific changes to this provision. The first, as Chairman Akers mentioned, is that the 30 days from the date of county executive appointment to the time at which the council must confirm that appointment has been extended to 60 days. And the reason behind this is, as you may know, the 30 days doesn't give quite enough time for council to have the full 3 readings necessary to carefully consider each appointee and vote to confirm or reject. The second change deals with appointments of emerging or underrepresented demographics. This was a recommendation initially submitted by the Next Generation Council to the Charter Review Commission, and the Commission incorporated some language basically saying that subject to any applicable qualification or requirements for officers and members of boards, agencies, commissions, or authorities, the county executive and council shall use good faith efforts to consider emerging and underrepresented demographics in making such appointments. Finally, the third change to section 2.03 deals with interim appointments, and it establishes an ambiguity, or it clarifies an ambiguity that currently exists in the charter as to the executive's authority to appoint interim officers and directors. And what this amendment would do is establish that the county executive may appoint officers and directors for a period not to exceed 120 days, and that any continuation of an officer or director beyond those 120 days or subsequent appointment to the same position would require confirmation by council.
Mike,
Yes.
if I may, real quick, and just to provide further explanation. So during this, for this charter amendment, when we discuss this, hopefully tomorrow, if we are uncomfortable, is uncomfortable with 60 days as an example, we cannot make the amendment to this. We cannot change the amendments. We will have to vote, recommend no, and then it's not even a substitute, a new resolution would then need to be presented to council for discussion and possible consideration. So keep in mind, if you're unhappy or don't like one of the provisions in here, we cannot amend. We can only accept or reject. Recommend and accept or not to place on the ballot.
Correct. Thank you for clarifying. Amendment 2 deals with campaign finance, and this provision, this amendment was submitted due to the lack of campaign finance laws as they apply to county government and the elected officials in county government, and there was considerable debate related to whether or not the charter should have specific campaign finance limits included within it. Ultimately, the commission decided that it was the role of the legislative authority to set those limits, but wanted to impose a duty on county council to enact campaign finance laws, including the establishment of campaign finance limits and donor disclosure requirements. Amendment 3 deals with the clerk of courts. As Chairman Akers mentioned, this is one of those issues in which the commission heard considerable testimony and ultimately decided to retain the appointment authority within the county executive, but required that the executive solicit the advice of the administrative judges of the courts served by the clerk of courts for his or her consideration in making such appointment. This would still retain confirmation by council. Amendment 4 is a considerable amendment related to the Board of Revision. This amendment, in a nutshell, eliminates the existing boards of revision that were established in section 6.02 of the charter and replaces it with a statutory board of revision. The statutory board is made up by the county executive, one appointee of the council president, and at either the fiscal officer or the treasurer at the choice of the county executive. This statutory board preserves political diversity in the way it does now by requiring that the council president's appointee not belong to the same political party as the county executive at the time of the appointment. And if a vacancy occurs in the appointee's position, the council president appoints a new member to finish. The council president's appointee may either be a member of council or may be an elector of the county and has a set term, whereas the county executive and either the fiscal officer or treasurer are ex officio members of the board. The statutory board does not hear complaints as to the valuation of real property itself, but instead establishes rules, procedures, and a hearing schedule, and appoints hearing panel members to hearing panels as is needed to deal with the volume of such complaints. The board also establishes merit qualifications for the hearing panel members, and there is a prohibition in the charter on ex parte communications between members of the board or hearing panels with other members for matters before hearing panel members, and requires that the statutory board establish rules, policies, and procedures to ensure that the system is administered fairly. Finally, it allows the board to utilize existing boards of revision that are in existence as of the time that this proposed amendment is adopted, its effective date, that the board may retain those existing boards of revision as hearing panels going forward. Amendment 5 deals with actions of council not requiring executive approval. Chairman Akers touched on this as well. This is basically items that are either unnecessary, redundant, or it would be improper for the executive branch to have veto power over the council's action. And so I'll go through them very briefly. They deal adoption or amendment of the rules and order of business of the council, adoption of the schedule of council meetings, creation of committees, other actions related to the internal operations of the council, adopting organizational structures for council offices consistent with the county's operating budget, hiring and setting compensation for employees of council's offices consistent with the operating budget, approval of contracts or amendments or contracts not to exceed $100,000 for services for council office consistent with the operating budget, confirmation of appointments by the county executive, making appointments designated to the council by the charter, adopting resolutions to require the attendance of any county employee or officer to council meetings, so subpoena power, adoption of resolutions to compel the attendance of witnesses, again subpoena power, or refer matters to the prosecuting attorney in accordance with Article 3, Section 12, or the submission of proposed amendments to this charter to the electors of the county. Amendment 6 is the memorialization of the office or the agency of the Inspector General in the charter. In addition to it is internally consistent with the existing Inspector General ordinance, but includes a couple of additional things that I'll highlight. One is it establishes subpoena power for the Inspector General. It grants the Inspector General independent contracting authority and imposes specific limitations on the Inspector General and the scope of his or her investigation. Amendment 7 deals with redistricting and the council residency requirement. This amendment is proposed basically to allow council members to serve the remainder of their elected term if they no longer reside in their district due to redistricting. This reduces political concerns in the event that one or more council members ended up in the same district, and there would be no member of council would basically be kicked out of office prior to the expiration of their currently elected term. Amendment 8 deals with the executive residency requirement, and basically this establishes a residency requirement on parity with the council residency requirement that the county executive shall have been an elector of the county for at least 2 years immediately prior to the filing of the declaration of candidacy rather than at the time. Amendment 9 deals with the allocation of legal duties between the county prosecutor and the law director, and I'll start off by saying that the law department did not act as legal counsel to the commission on this issue. The amendment clarifies the duties of each office and basically retains the current status of the prosecutor's office continuing to represent the county authorities in court. And if the commission has any questions as to the rationale, I would defer to the commission members as the debate continues. Amendment 10 deals with the appointment and term of the Charter Review Commission. This amendment was proposed basically, I think, with concerns by members of the commission that they were initially appointed in September of last year, and by the time they were confirmed, they had less time than they initially anticipated to review all of these issues and make recommendations. So this amendment would establish that before the first day of July, the county executive in each year that a Charter Review Commission is to be appointed will make those appointments, and that the confirmation, or that the term of the Charter Review Commission members would commence on the first day of September. And this is also I think, meant to run concurrent with the 60-day appointment schedule to allow the council to confirm the appointments within 60 days, such that the confirmations would necessarily take place prior to the commencement of their term. The 11th Amendment deals with proposed changes to the executive vacancy, and there are two principal changes here. First deals with executive succession. The first is a change to both are changes to section 2.04, but establishes that the county executive shall designate, subject to confirmation by the council, one officer appointed under Article 5 to succeed as county executive on an interim basis in the event the office becomes vacant prior to the expiration of his or her term. The second in line would then defer to the council president, who is currently first in line under the existing charter language. In the event, and as it says, in the event no designee of the county executive qualified under section 2.01 of this charter has been confirmed, then the president of council shall succeed. The second change deals with the length of appointment when the vacancy occurs. And this is an issue that deals with both amendments 11 and 12. And basically, the current language establishes that if a vacancy occurs in the first or second year of a 4-year term, the interim appointment shall be for a period until the next countywide general election. This language doesn't provide clarity when it comes to vacancies that occur within the second year of a 4-year term, but after the filing deadline for the primary before the general election. So what both of these amendments would do is provide that the interim appointments would be for the remainder of the existing 2-year term if it's before the 30-day filing deadline for the primary, but if it's after that filing deadline, then it would be for the remainder of the term. And Amendment 12 basically applies the same requirement, but applies to council vacancies instead of executive vacancies. Amendment 13 deals with a justice system audit, and this would require that every 5 years, beginning in 2014, the county executive appoint an independent organization to conduct a performance audit of the justice system, and would recommend best practices to improve the efficiency, effectiveness, and fairness of the system. And the organization selected by the county executive would be subject to confirmation by council. Amendment 14 deals with the term and appointment and removal of the county sheriff. Currently, the county sheriff, along with all other Article 5 officers, serves at the pleasure of the county executive. This would establish a staggered term for the sheriff that would run 4 years and would begin 1 year after the county executive starts office. His term begins. Then the sheriff may only be removed from office by the county executive prior to the expiration of that 4-year term, with the approval of at least 2/3 of council. Finally, Amendment 15 amends Article 9 of the Charter and has one small amendment to Article 2.03 of the Charter, dealing with the Human Resources Commission. This does several things, so I'll go through them. I'll hit the highlights here and go one by one. First, the Human Resources Commission is renamed the Personnel Review Commission. This is to clear up confusion that I think exists for a number of people between the Human Resources Commission and the Human Resources Department, and would require the Personnel Review Commission the new Human Resources Commission, to submit a recommendation regarding any ordinance concerning council or county personnel policies prior to passage by county council. And if they do not endorse a personnel policy, the Personnel Review Commission would issue a statement of non-endorsement. Second, in 9.02, the amendment would clarify the appellate jurisdiction of the Personnel Review Commission to include classified employees who work for the under the county executive, prosecuting attorney, county planning commission, and the county public defender, and ensures that the Personnel Review Commission has authority to ensure compliance with federal and state laws within the county executive's organization and department. So the regulatory authority would be within the county administration. And a new subsection 4 in 9.02 establishes that the Personnel Review Commission have responsibility for the creation of rules and policies related to the Personnel Review Commission's authority set forth in the charter. Uh, 9.05 is the next major substantive amendment. Permits the Personnel Review Commission to delegate duties to the Human Resources Department and establishes that the Human Resources Department report regularly to the Personnel Review Commission in the performance of those duties. There is a new section 9.06 establishing the Director of Human Resources as a charter position, establishes the powers, duties, and qualifications for the Director of Human Resources, and would require council confirmation and require that the Director of Human Resources have a minimum of 5 years of experience advising or working in the public sector, experience in employment-related matters, management experience, or related relevant experience. Finally, section 2.03, which deals with the executive's powers and duties, subsection 12 is amended to say that the county executive is empowered to conduct collective bargaining with any recognized employee bargaining unit rather than in conjunction with the Human Resources Commission to provide quarterly reports to the Personnel Review Commission regarding the county's collective bargaining strategies and approved contracts. And I think this was an acknowledgement that the Human Resources Commission would not be conducting the collective bargaining on behalf of the county. So that is all. Those are all 15 of the proposed amendments, and brief rationale and explanation of the intent behind each one. I will also now briefly go through the 6 minority reports and address each of them. The first minority report, it begins on page 39 of the report. In Appendix C, was submitted by Kenneth Callahan, joined by Maisha Wilson-Hedden. And this minority report relates to proposed Amendment 3, dealing with the Clerk of Courts. And Councilman Greenspan, would you like me to just read each of these, or would you prefer
If you can just provide you don't have to
Sure,
read,
okay.
just a summary
That's
of
fine.
each.
This minority report basically argues that the Clerk of Courts is a judicial branch entity, and that the appointment of the Clerk of Courts should be made by the administrative judges or have an elected Clerk of Courts rather than a clerk appointed by the county executive. The second minority report, submitted by Mayor Akers and joined by Nancy Dietrich and William Tarter, deals with the duties of the law director and prosecuting attorney, and basically advocates for having the director of law be responsible to act as representative and counsel for county entities, both in the administration and county council, in court, including civil litigation and other administrative proceedings. The third minority report, submitted by William Tarter, seconded by Mayor Akers and Nancy Dietrich, is a report dealing with campaign finance reform. This minority report was submitted to suggest that the charter includes specific, maybe not specific, campaign contribution limits, but to tie the limits to those set by the Secretary of State at the state level, and would, I believe, link the council's campaign finance limits to those of House representatives at the state level, and the executive campaign finance limits to those of statewide elections at the state level. The fourth minority report, submitted by William Tarter, seconded by Mayor Riley, deals with retire, rehire, and there are two discrete proposals here. The first would bar county employees from retiring and being rehired under PERS. And second, to allow for employees to retire and be rehired, but with the requirement that once rehired, employees would be required to donate half of their salary to the new county education fund. The fifth minority report deals with a nonpartisan primary. This issue came up on multiple occasions. The basic proposition is that rather than having two partisan primaries, you would have a single open primary and then a general election between the two highest vote getting candidates regardless of party. Finally, the sixth minority report deals with filling vacant county council seats. And this would eliminate the requirement that party precinct committee members choose the individual to replace a council member affiliated with a political party, and would simply require council as a whole to make the appointment of the vacant seat. So those are the six minority reports, and I'd be happy to answer any questions you may have related to the intent or the rationales. But
Great, thank you. And just to remind the committee, the items we'll be discussing and voting on over the next few days are our amendments, proposed amendments 1 through 15, not the minority report items, but I just felt it would be appropriate for the committee to understand the totality of the work that the committee undertook in presenting and preparing their report to us. Are there any questions, Mr. Miller?
I would just like to ask a question of clarification about Amendment 15 on the Personnel Review Commission. Sure. And I attended the meetings when this was discussed, and my recollection was the same as you presented, that the Director of Human Resources be appointed by the executive subject to confirmation by the council. Mm-hmm. However, the language in section 9.06 in the report does not seem to reflect that, so I would like some clarification.
okay, I can speak with the Chairman Akers and discuss. I will refer to my notes and see if that amendment, I know this was one of the amendments that was voted on in the last session as amended, and I will double check to make sure that there was nothing that was failed to be incorporated into this amendment.
Great, thank you. Thank you for that. Just to review the schedule, and it looks like we'll conclude this meeting early so Mr. Mayor Akers can make it back to his family in time for dinner. This evening, we will have the first reading of the 15 items. The second reading will then be on the 23rd, and the third reading is scheduled for the 13th. If any member of council wishes, as I stated earlier, to bring forward their own resolution, proposed amendment, then the first reading for that would be on the 23rd, second reading on the 13th, and third reading on the 27th. So there is time within our normal committee schedule to have individual or council member proposals brought forward. I believe it's a question from Mr. Schron.
Thank you, Mr. Chairman. Can you give me the law director's points of view as far as the effective dates that these would all take place? Assuming that, let's assume that an item passes and then the results get certified. What would be the effective date of a few of these? And I'll go into a couple specifics on.
The effective date under the Ohio Constitution is 30 days after the results are certified, unless otherwise specified within the amendment. So I don't think any of these amendments specify alternative effective dates, so it will be within 30 days after the results are certified.
So from my understanding then, on that basis, contributions that are going into candidates as of right today could be exceeding some of these things if we adopt them and things of that nature. And then the other would be, for example, on the appointment of a successor name for the county executive, in theory, could be put in place County executive could name that person, steps down, and we have a new county executive by February 1st. Under this, is that is that the intent of what was brought forth by this charter review, that we could have a new county executive theoretically within 30 days certification, and that person's name's put forth and they go through, and we actually are looking at a county executive before that time?
I can't say to my recollection that any conversations necessarily came up on having that appointment happen immediately, but it is within, I mean, the commission was advised that the effective date of all of these amendments would be 30 days after certification by the Board of Elections. So that certainly was contemplated, if not overtly discussed. So,
I'm sorry, Mayor Akers.
Councilor Strong, if I may have misunderstood your question. The idea was that the county executive would designate from among his, and specify some specific department heads, who would be the successor should that office become vacant, but that designation would be approved, confirmed by council. So that's not a situation where, if I understood your question, that's something where something could change that without council already having confirmed that designation of a potential successor should the office become vacant. Does that answer your question?
If the person is already on staff and has already been confirmed by this council, and it happens to be a staff member, would they have to go through a second confirmation process?
You confirmed.
I don't read that in this document.
The confirmed all of the various department heads, council has already confirmed. Now the second step, if this amendment were adopted, that the county executive would designate one of those department heads as his potential successor should the office become vacant. That designation would have to be confirmed by council.
Okay, so once that is done, and you have a 2/3 vote of this council, then that next day, the county executive could step down, and we have a new county executive.
Conceivably, yes.
Yeah, as opposed to, you could have picked a date that said effective in the future after the next election, after the next county executive. Because you said there were no interim dates chosen for a single one of these 15, is my understanding.
Yes, that's
Okay,
correct.
thank you.
All right, thank you. Madam President.
Mr. Chair, I just note the time, it's about 10 minutes to 4. And did you intend to adjourn? Because I mean, since we're all here, it would seem to me that we could start the discussion since we're going to be here for the next 2 days and we don't have our other meeting start till 5.
We could do that. However, we cannot take any action because these items
No, but I'm
have
just
been
saying if
referred-
we at least start the discussion since we're all here and we have about, we could at least take 45 minutes to start the discussion.
If that's the pleasure of the committee, I'm amenable to that. It looks like, hearing no objection, we can begin that process. That wouldn't be a problem. With that being said, then we'll just move ahead as if we were in tomorrow's meeting agenda without the opportunity to vote. And the first item then that we'll discuss will be item number 9, Amendment 9, the duties of the prosecutor and law director. So the intent here, if you would then lead into this, into the amendment, and then we'll open the floor up for discussion in a little, so you can go to a little more detail into this than you did in your previous explanation.
sure. Just to reiterate, the Law Department did act as counsel to the Charter Review Commission on a number of these amendments. We did not act as counsel on this specific amendment dealing with the, there's an inherent conflict here. So I can basically go through the specific language and convey at least my understanding of what the Commission's intent is with this language. So, except as provided below, the Director of Law shall be the legal advisor to and representative of the County Executive, County Council, and all county departments, offices, agencies, and other authorities responsible to the Council and the County Executive. And then, in addition to the qualifications, it breaks out and has 5 separate responsibilities of the Director of Law. First, give written opinions as to the law when specifically requested to do so by the Council or the County Executive. 2, represent the county executive, and the council in administrative proceedings and labor negotiations. 3, act as counsel for the county executive, and/or the council, except upon the initiation of any court proceeding instituted by or against the county of Cuyahoga, the council, the county executive, or any of the other entities listed in this section. And 4, perform any other duties assigned by the council or county executive. And then there's one additional section in 4.01, basically qualifying that the prosecuting attorney shall be elected and, subject to the provisions of section 5.06 of the charter, the duties of that office and the compensation therefore shall continue to be determined in the manner provided by general law.
Okay, very good. I'll ask at this point Chairman Akers if he wished to add any comment to this proposal since you're here today. And
No, I think as I said in my initial comments, the majority of the council, the commission, excuse me, are endorsing the recommendation that Michael has just read. The minority felt that recommended that the law director be able to handle all civil litigation for the county, or for all those aspects coming out of the county executive. But that's really, when you get through, that's the main difference of opinion. But the majority favored, as you just heard from Mr. King.
So the fundamental, just so I'm clear and then we can be in discussion, the fundamental purpose of this is to separate the criminal prosecution from the civil litigate, or the civil, basically criminal versus civil side of the prosecutor's position, and to give the civil responsibility to the law director and the criminal prosecution, the criminal.
That's the minority point of view, yes.
That's the minority point of view, okay.
Yes.
All right, Mayor,
If I may, and for the record, Sean Riley. Since I was in the majority, maybe it makes a little bit of sense for me to explain how this played out. The language that we've actually proposed, that the majority recommended, divides or makes the division of authority really one as between counseling and advising on the one hand and litigation on the other hand, with an exception for administrative and labor matters that end up in litigation. We used as our model the federal system in which the U.S. Attorney's Office typically takes over matters from the various agencies when it reaches a litigation stage. And we specifically rejected as a majority this concept of splitting civil versus criminal. We thought that it made no sense for the county to strip away from the prosecutor's office the civil division, which is operated very effectively, and move it with no clear need to do so. Consistent with our overall approach to this, that we weren't trying to fix things that weren't broken, but rather in this case trying to clear up some ambiguity.
okay, very good. Any questions from Ms. Simon?
Given that the majority had a longer discussion, I'll have
Okay.
the concern here on the minority's part was that it is potential, no reflection on current people in the office, either prosecutor or law director, but that it made sense, we felt, that the law director should represent in civil litigation those issues that involve the county, and that it is conceivable, as we try to point out in our minority report, that you could have a situation where the prosecutor may have a conflict between doing his responsibilities of handling, in the case of a lawsuit, which may be in conflict, or where conceivably could be in conflict, in trying to represent the prosecutor side and representing the county executive side at the same time. So that's how we felt. This should be clearly put on the law director.
Okay, very good. Thank you. Ms. Simon?
Thank you, Mr. Chair. I want to address Mr. Riley's statement that there was no indication that there were any problems, and if it's not broke, don't fix it. There were people testifying before your commission that there were actually examples of some issues that had arisen and may arise in the future, especially around the conflict issue. Do you recall that testimony?
I do
Yeah,
recall
so
some
I
testimony.
just want to be clear that there was testimony that there were some issues, and those issues actually exist, correct?
There was testimony that there were some issues, yes.
Thank you. And,
Okay.
and the federal model you explained that when litigation arises, those matters would be directed to the U.S. Attorney's Office, correct?
That's my understanding.
Yeah, and the U.S. Attorney's Office comes under the U.S. Department of Justice and the executive, the president.
Right, and I know where you're headed. It's not a perfect analogy, but it was the one that the majority thought best fit what we were trying to accomplish.
Well, if we were to actually use a federal model in that case, then the actual litigation in the county would come under the executive branch in a civil litigation division.
Right, and that opened up a whole set of issues about whether the prosecutor should be appointed by the county executive so that the county executive, the one elected official at the executive level, would have control over both civil litigation and prosecutorial issues, much as the president does in the federal system. And I don't think we heard I don't recall testimony that suggested that there was a need to go down that path about having an appointed prosecutor.
Thank you. I just wanted to be very clear, though, that this is not consistent with the federal model. If when we look at the top of that chain, the federal model is the executive branch.
No, I agree. It's
Yes,
not a perfect
right.
analogy, but that's the closest we could come up with. Other than, I mean, if we wanted to make the analogy perfect, we would have suggested, I guess, that we have the prosecutor appointed by the county executive and have the prosecutor handle criminal matters and the law department handle civil matters.
Right, and would there be any problem with doing that type of model consistent with the federal model where the executive branch in the county would handle the civil litigation and the prosecutor independently elected would handle the criminal? Were there any specific problems with looking at that model?
Problems. I don't know that there were problems as much as there was a belief that the system is currently working, or is currently set up as working fairly effectively, and that at least it was my view, there wasn't a need to strip away the civil division out of the prosecutor's office and fold it into the law department.
Okay, thank you. Mr. Chair, I'd like to revisit this down the road if we can.
And we can't take any action here today, so tomorrow we will, before we bring this item up for a vote, we will bring it up for discussion. Yes.
Mr. Chair, briefly, I cannot be here tomorrow. That was the one day I thought, so I'm wondering if we can move this till Thursday.
Well, I'll take that under advisement. I don't think there'll be an issue with that since the intent was for Mayor Akers to be present today. Is it possible for me to? Sure. I mean, I think it'd be appropriate to hear those who crafted this legislation or who were pro and con to discuss.
Thank you, Mr. Chairman. Let me just add a little more background on this issue. I don't think there was a single issue that was discussed, really debated more than this one. We had more individuals appear before us on the issue of clerk of courts, I think, and address that. But on this issue, I think we discussed it and debated it more than any other. And Judge Callahan was not present the day we voted, and he stands in the majority. So it's a 6-3 majority view on this point. And really, if you look at the U.S. Attorney's Office, something I know something about having spent 10.5 years in that office, the U.S. Attorney handles both civil and criminal. Of course, same thing the county prosecutor does. And on the issue of whether or not there were problems, it's my view, having been at all the meetings for the exception of the couple that I was out of the country on back in January, that we were not presented with any single specific problem issue. The subject of conflicts came up, but that's not unusual. And it's not necessarily conflicts from the county prosecutor's office, it's also conflicts from the law director's office. In other words, it's sort of a two-way street. And there were no specific problem issues that were brought to our attention, aside from maybe some hypothetical situations. And so, based on what I heard, things seem to be working pretty well. And then I know they're working on a memorandum of understanding. But nevertheless, the charter is ambiguous. And I think what we sought to do, and I think what this provision does do, is eliminates the ambiguity. Because the current provision in section 4.01 indicates that the prosecuting attorney shall continue to be, in terms of what he does, his duties, shall continue to be determined in the manner provided by general law. General law now gives to the county prosecutor the authority to handle all civil litigation on behalf of the county in court. Here, I think what we've sought to do is we made it clear that when the case gets to court, the county prosecutor's office would handle it. But so many other duties and responsibilities previously handled by the county prosecutor's office would be reposed with the director of law. And we thought that that was a fair and appropriate way to do it. And so, so those are some of my thoughts. And I think that, again, the law director was there, and he helped us, I think, in raising the issues that he saw from his point of view, and he did an excellent job. I think we considered all the points, and this is the provision that we came up with. So,
Thank you. Mr. Tarter, before you come to the microphone, Mr. Schron.
Yeah, as long as we have Mr. McLaughlin up there. Your comments on that were that, at least I think I understood, that the prosecutor as an elected official is where those normally reside under the Ohio Revised Code, these functions.
yeah.
But for that first draft of the charter, having that same functional officer sitting there during the process, and it ended up being that there was only 2 elected offices left, county executive and the prosecutor, and there was, my understanding, serious discussion even back in those days to only have 1 elected office.
Right.
We would be, at that point in time, and I see Mr. Akers' head nodding, that was a serious discussion to actually fold that directly on in. Would you have any problem had they have done that and both the civil and criminal sitting underneath the law director?
Well,
under
Mr. Schron, that's hypothetical.
I understand that, but
it didn't happen, and I can only look to what the drafters of the charter and the citizens of the county actually did, and what they did is set forth in 4.01 and 5.06, and so they created an ambiguity which has caused, I think, some of the problems, and they didn't do it that way. Now there were occasions when it was suggested in our discussions at the Charter Review Commission that we ought to actually consider whether the county prosecutor should continue to be elected in Cuyahoga County or should be appointed. And clearly, I mean, it's not an issue that we brought to a formal vote, but clearly the consensus was that we would not recommend a change in that. And I personally believe that the county prosecutor should be elected by the people.
had they had that done, the civil division would be under, as both divisions would be. So it's no longer hypothetical, because now we're discussing should the civil be underneath the law director. And I understand that the opinion coming forward also had a very, very strong minority opinion that the civil division should be underneath. As a litigator, you indicated that there's a lot of workup that will be done by the law director on the case, at least my understanding, and then when it gets to trial, be flipped over to the county prosecutor if it's a civil matter under this proposal?
Yeah, well, that's the way it works now in the federal system, and that's where the analogy is right on point, where by the time a case gets filed in court, whether against a federal agency or an official or by them, a lot of work has occurred at the agency level, just as the county the law director's office would do a lot of work in advising counsel, advising the county executive. But yet, when the case goes to court, then you have a core group of litigators who go to court and defend. And sometimes it's not a bad idea to have a second look at what the law requires, and that's what happens when the cases get to court. It's a system that works well, and even the law director indicated in one of our meetings he thought that was the gold standard.
Okay. Do we have a recommendation from the county executive on this, as far as this particular piece?
If I may, County Executive Fitzgerald presented to the commission early on and did make some comments about the need to address what I believe were some of the to eliminate any potential inefficiencies or overlapping of operations. With that in mind, and I don't want to delve into it, but I think the chair and perhaps some of the other members of the commission have addressed, there have been some discussions on hammering out an MOU. I make no comment. I have no idea where they are in that issue. But with that in mind, I do think that there was some desire to have this commission look at it, and this was right from the get-go. And as it relates to what specific instructions or desires, he has never given any specific ones that I'm aware of to myself or members of the staff.
As to whether we'd follow the minority opinion or follow the majority vote?
No, and I think part of that is based on the concept that again, and not saying in a flippant manner, but I mean, this is the charter mandate that this comes to the council for the next step. And, you know, with that in mind, I don't think that there was a desire to step on anyone's toes as this process went further.
Thank you.
Okay, very good. Mr. Rogers and then Mr. Miller.
I just, for clarity, we currently, if the council so chose, we could go to the prosecuting attorney and seek an opinion or advice. Does this new amendment forbid the council from doing that?
I don't believe that it would, because I know now the county prosecutor's office and the law department are cooperating in terms of how responsibility should be allocated. But I think that council has the right to seek legal opinions. Certainly, you can get it from the director of law. I think we strengthen the position of the law director's office, but I don't think that anybody could say to council or the executive, for that matter, if they wanted to also seek advice from the prosecuting attorney's office, that could be done. And in fact, conflicts may come up whereby the law director would not be able to represent perhaps members of council or the executive on some issues because of a conflict, whatever that may be, and vice versa. And so the other official would have to provide the legal guidance.
Thank you. Mr. Miller?
Okay. Mr. Chairman, a question for Mayor Akers, if you would. As the chairman of the commission and the one member that participated in the original drafting that's here, am I correct that the original intent of the commission was that the law department would perform the civil duties, but and the prosecutor's office would perform the criminal duties, but somehow the language didn't exactly turn out that way? Could you kind of elaborate on that?
Council Miller, that was the intention of it, and we goofed in not making it clear, very simply. And that's why we're in the situation we are today. But it was the thought, and I know I can speak for my two fellow co-chairs of that, Mayor Russin and Mayor Zanotti, that's what we'd hoped for, or what we anticipated, we planned for. But we sure didn't do it. It didn't catch that in the writing before of our slip-up.
Okay, thank you. And one question for Assistant Director King. My question is if you could provide a little further detail on the rationale for the minority opinion.
Sure. Minority opinion, let me pull up to it, makes, I think, three major points. The first being that having the prosecutor represent county agencies can create a duplication of efforts. In that the law department does have attorneys working on matters, advising clients within the county, and as soon as the determination is either made to sue, or in the event the county is sued, the matter must go to an additional attorney in the civil division of the prosecutor's office, which in some cases may be appropriate and in others may not be necessary. The second is that the ability of the county executive and county council to choose their own legal counsel, and the concern that if a member of the executive or any department within the executive's office, the county administration, is dissatisfied with representation by a member of the prosecutor's office, their ability to choose alternative legal counsel is limited under the status quo. And finally, the final point made in the minority report is that as the charter is currently established and as the commission determined in its deliberations over whether or not to have a separately elected prosecuting attorney or one appointed by the county executive, is that the separately elected prosecuting attorney, the purpose behind and the decision made to retain a separately elected prosecuting attorney is to act in part as a check on the county executive in the event there's any wrongdoing or need for some type of oversight. And in those instances, there could arise a conflict of interest, and it would be inappropriate for the prosecutor's office to represent the executive in court.
Mr. Chairman.
Yeah, Mr. Miller.
I would just add a comment that one of the basic premises of the charter was to eliminate duplication and conflict between independently elected officials, and I think for the executive and the executive's agencies and the council to go to another independently elected office for legal representation in court, to my mind, that conflicts with part of the basic principle of what we're trying to accomplish here.
Very good, thank you. Madam President?
Members of council, council is faced with very, very onerous decisions in reviewing these items. And Mayor Akers said something to the effect that the language didn't turn out to be as clear as we thought. And that's my concern, whether we're talking about this proposal or others, that we have to realize that we might think that the wording means a certain thing, but at some point a court or someone else could believe it to mean something else. So I just think that we have to consider the language, and unless we are very, very clear that it's going to make a change that's positive and it's definitely what we want, that I'm reluctant to change. I mean, I always tell people when they ask me about, what they should vote on a particular constitutional amendment that's on the ballot or charter amendment, look at the unintended consequences. So I just think that I'm very concerned that we have to realize that the unintended consequences of all of these, if we start changing things and then a court or some other parties look in the future and say, well, no, they didn't really mean this, they mean that. So I'm just take the conservative view for once in my life, I guess, that we don't.
It's the seat you sit in.
It's the seat I'm sitting in. I should have never sat in this seat. But we don't change. You don't change the charter or the Constitution on a whim. That we have to make sure that this is definitely what we want, and this is definitely how it should be changed. So that's just my concern as to this amendment and all. That we got to make sure what we're getting our future generations into before we start changing it.
Okay, very good. Any other Mr. Tartar, I apologize.
Thank you, Mr. Chairman. Just wanted to, William Tartar for the record, just wanted to clarify, answer a question that Councilwoman Simon presented, was if the discussion was ever had on if the prosecuting attorney should be elected or appointed. There was discussion on that particular issue. There was a motion put forward, but it was not seconded, and therefore it was not a part of the record, not just the report, but also not in the minority reports, because there was no second to that proposal. So just wanted to answer that was discussed and addressed during one of our meetings.
Very good, thank you.
Thank you, Mr. Chairman.
Thank you. At the request of Councilmember Simon, I don't see any reason why we could not put this up for a vote on Thursday, so her presence would be here, and I believe, unless Mayor Akers has any objection, very good. Mr. Germano, did you have a comment?
Thank you, Mr. Chairman. And I've brought this point up previously, but, indirectly, whenever the notion is that the voters decided all these various different points. Well, really, the voters only had the choice of accepting the whole document or not. So, I think we've got to remember that we don't know if 80% of the voters were against a certain provision in the charter, but as a whole, they had to accept and make a vote. So really, the responsibility was on the framers to get it right in the first place. And that's why this Charter Commission is so important, because if there are things that need to be corrected, or in the view of the Charter Commission that it should be corrected, then the people have the choice of accepting what was originally done or the amendment. So I just don't accept the fact that people, by approving the charter, were in favor of everything that was in the charter.
Okay, very good. Madam President, it looks.
I don't want to get into a debate, and I understand your point, but I just think that we have to be careful what we start enacting, because you're stuck with it for a long time if you start changing things. So.
Okay, very good. Any further discussion on proposed amendment number 9? Okay, hearing none, we'll move to amendment 14. Mike, if you can come forward. We'll go through the same process. It appears on this one that there is no minority on this vote. It was 6-0, at least those who were in attendance at the meeting that day. With that said, then followed by Mike Mayor Akers, if there's somebody who would like to present the majority opinion on this.
Amendment 14, again, establishes that the county sheriff be appointed for a term of 4 years that commences 1 year following the commencement of the county executive's term, and that the sheriff may only be removed from office by the county executive prior to the expiration of his or the sheriff's term, subject to the approval of at least 2/3 of council. And this is in contrast to the status quo in which the sheriff serves at the pleasure of the county executive.
Very good. Mayor Akers.
This one had a considerable discussion, as has been mentioned before. But as you see, it was a unanimous vote that we maintain the appointment of the sheriff with county council approval. As the discussion went on, we felt very strongly that the independence of the sheriff position needed to be, we should be mindful of that and aware of that in our deliberations. Hence the thought of staggering the term, still a 4-year term, but staggering it from the executives. But more importantly, that should the executive, for whatever reason, wish to remove the sheriff in the middle of the term, that it would be 2/3 of council would have to approve that. And we felt that gave it a little more check and balance and a little more guaranteeing the independence of the sheriff position.
Mayor Akers, I have a question before I open it up. And then Mr. Gallagher, is this amendment saying that the sheriff is term limited to it says a term of 4 years. Does that mean that the sheriff may only serve one term?
No, we weren't saying that, no.
So they are subject to reappointment?
Yes. Okay. But confirmation by council.
Oh, right, correct. Mr. Gallagher.
Mayor, it would seem to me that the sheriff and the clerk of courts are kind of in the same boat. Why was it not provided in the charter recommendations for the clerk of courts the same option of a staggered term?
Councilman Gallagher, frankly, that point did not come up in reference to the clerk of courts. The feeling was, given the investigative powers of the sheriff, that should, for some reason, in the course of those duties, the sheriff doing some investigation of someone in the executive branch, that was important. Therefore, it's important that we put this check and balance, as you would call it, for sake of a better word, have this matter that, again, let's take the hypothetical case, that investigation by the sheriff into somebody in the executive wing, and for whatever cause, that then sitting executive would want to remove him. we thought the check there was here, the safety factor or safety valve was that the members, 2/3 of the members of council had to approve that removal of that sheriff. Using your analogy of the clerk, we did not discuss that aspect in the same vein. The feeling there was that, though again there's a minority report on it, that there was a check on the judicial budget, in fact, the judicial spending, by having the clerk be appointed by the executive, confirmed by council. But again, to address one of the major concerns by the presiding judges, that at least the county executive, he or she would consult with the presiding judges on their recommendations. But there wasn't the same sense of check and balance as there was in sheriff, to answer your question. That issue didn't come up. That discussion didn't come up.
Well, that may be an issue for us because that certainly has come up with us, as if you are not aware of the tug of war that we've been having over that office. So I think that would be a provision that should be applied to the clerk also, and we'll discuss that. I look forward to that debate. Thank you.
Thank you.
Any other questions on this one? I just have a question. I'm sorry, Mayor Akers. When I guess my question comes into interim terms. Let's say we have a sheriff who leaves 2 years in to his term. Does this mean that the 4-year clock starts over upon their appointment?
4-year term would commence on January 1st, 16, yes.
Right, so if in 2018 a sheriff leaves, a vacancy exists for whatever reason, then is that newly appointed sheriff appointed for a fresh 4-year term? Because then you might...
Yes, that's the idea, was it'd be 4 years term starting in 2016. And that provides, that establishes the staggered from the county executive's term.
So then what would happen is, regardless in January 1 of 2020, a new sheriff would be appointed, even though there might be an interim sheriff that served 2 years. You understand, my issue, it says the sheriff may be appointed for a term of, shall be appointed for a term of 4 years. So if we have a sheriff in 2018 who gets a new sheriff is put into place, is the expectation that sheriff is there for 4 years, ending at 2022?
2020. Councilman Greenspan, if I understand your question, the idea is that if this were adopted, the new sheriff would be appointed to create the staggered term. The new sheriff would be appointed, to take effect January 1st, 16. He or she would serve the 4 years from that, so 16 through 20, and then 4 years thereafter. And that staggers from the county executive's terms.
Okay.
Did that answer your question? I'm sorry.
I see what you...
Can I supplement
Yeah.
the chairman's comments on this? Speaking for myself, when we debated this issue, I considered a 4-year term to be that the individual is appointed for a term of 4 years. So in the event that he or she would then leave office 2 years in, then and a new sheriff is appointed, the new sheriff would be appointed to a 4-year term. So it's the 4-year term of office that is made. And so the check here was in part to prevent the county executive from firing the sheriff within that 4-year term of office without coming to council and getting a 2/3 vote of council that agreeing that the sheriff should be terminated. So we thought that strengthened the position and independence of the sheriff in that respect.
But wouldn't that point be made with just the last sentence, removing the sheriff will be appointed, shall be appointed for a 4-year term, just leaving the provisional language as far as removal? Wouldn't you achieve the same objective? The concern was the removal. The concern wasn't necessarily a 4-year term.
Well, the 4-year term gave the sheriff a term of office, and then and more independence, so that if you wanted to remove the sheriff within that 4-year term, at the end of the 4-year term, the executive can reappoint someone else and bring that individual before council. But to remove him or her within that 4 years, then the executive would have to come to council and get 2/3 of council to agree. Otherwise, then, if council did not agree, then the sheriff would then fulfill the 4-year term, but then the seat would then be up again for reappointment. Could be reappointed, or a new individual could be appointed.
I see the point there.
That's how we talked about it,
Okay, Mike.
in my view.
Yes.
And then
Just to supplement, that exact question came up in one of the commission meetings, and I think the reason why the 4-year term was included was the initial intent was to include a protection for the sheriff from removal, but if you don't establish a term of years for that appointment, then you have a sheriff that potentially serves in perpetuity unless you have the county executive removing with 2/3 majority of council. And so the establishment of the 4-year term followed that initial creation of protection for the sheriff.
Mr. Chair?
well, Mr. Schron, then Mr. Miller, then President Conley.
Does this language ensure that we will not have an overlap potentially between the executive and, because the way I read it at first, it sounds as though it was designed not to make sure that we have an overlap, that you have a juxtaposition between the county executive's term and this person's term. Is that the intent of the language?
The intent was to stagger.
To stagger the terms.
To stagger, yeah. I think this gives a 1-year staggering, but.
But if somebody were to.
In answer to your question.
It doesn't guarantee that, does it?
No. Is it conceivable that depending on when sheriffs might leave and be reappointed, I suppose you could all be realigned together so that it's not staggered as much, but I would think that would be somewhat unusual, but it certainly could happen.
But it's well within the chemistry that when an executive leaves, so does the chemistry of the working staff. So we're replacing, and we've missed that ability to stagger if the resignations come when the executive leaves and you have a fresh new team coming in. That risk is that, so we have to make sure what we're trying to accomplish by this language is,
Right.
as I think our council president points out, be careful what we wish for, because we might not end up with that staggered
Right,
term.
right.
Which was the priority, staggered term or 4 years?
Well, we wanted to stagger, but we felt that in order to give the independence to the sheriff to be appointed for a 4-year term, that was important as well. So we thought they were both important. We felt it made sense to stagger them, but I agree with you that there could be circumstances, we can imagine circumstances whereby it might be brought together. But of course, council also controls the appointment process, so you would determine when somebody would be confirmed for the position ultimately.
With the IG, we chose a 5-year term, which means that there's no way that they can ever automatically line up forever in perpetuity out there.
No.
Oh, do they? Yeah.
We could probably conjure up some hypothetical.
Yeah.
but
60
it
years, he
might-
pointed out that potentially, none of us in this room are going to worry about that.
Okay, Mr. Miller?
Mr. Chairman, my question was essentially the same as Councilman Tron's. I'm concerned that as it's described, that we don't retain the staggered provision.
Yeah,
President Conley?
I agree with the same point. I mean, I think 4 years is 4 years, and so if Sheriff Garfield dies in the first 4 months of his office, when he goes over the train station and gets shot or whatever, if at the end of that, if he dies within the first 3 or 4 months, then we should appoint someone for the remainder of the 4 years, so that it's always on the same term. That's my only concern. And of course, council could always do that. So we have a sheriff that we appoint, and in a year they die or whatever, then we could just appoint somebody for the remaining 3 years. That always will keep the staggered term.
Mr. Gallagher?
But with the 4 years, it'll be maintained. 4 years takes care of that problem.
No, but I'm saying, maybe I misunderstood. I thought that we appoint a sheriff and he dies within a few months. Then I thought they're saying we're starting 4 years all over again.
No, you go.
You said.
Yeah, that's what they're saying.
Yes.
Yeah, I don't want to start the 4 years all over again. 4 years is 4 years. So there's a term of 4 years. The person serves for a year, drops out, dies, whatever. Then we appoint somebody else for 3 years. So that it always comes, yeah.
That's the 4-year term.
But it doesn't say remaining, it says here they'll
Say
start
remaining, yeah.
They'll start at,
And I don't want to start over a whole new term. Now, council could just do that. We say, okay, Sheriff, there's 3 years left on this term. We'll appoint you until
well,
whatever the end.
let's take the current sheriff environment that we have right now. So So right now, Sheriff Bova is serving until the term expires of the executive, this executive, because every executive has the opportunity to appoint his or her own sheriff.
Yeah, but he doesn't automatically, his term doesn't end.
I think he serves at the pleasure of the executive, regardless of who, whether
Right.
that's Ed Fitzgerald or David Greenspan for.
Yeah, Mr. Chairman, technically, that is correct.
that an endorsement?
You're appointed,
I didn't-
you're appointed in perpetuity. There is no expiration term on the appointment. Now, you serve at the leisure of the executive, so obviously when a new executive comes in, I mean, the history, the practices, the cabinet changes, but technically the appointment is, and you have that at the federal level sometimes when they retain a cabinet member who was there before, you don't go again through the confirmation or anything. The person just continues
Okay,
serving.
let's use this scenario with the current environment, though. So sheriff gets appointed for 4 years. And bear with me, so under this environment, it's the same concurrent 4 years as the executive. However, 2 years in, the sheriff leaves. We have a new sheriff who's appointed, confirmed. They don't serve till the end of that initial 4 years. They have a new 4 years, which goes into the next executive, the second term of a county executive. That's how this reads. Yes.
Thank you, Mr. President, members of council. This would run, if you don't mind me pointing out, in Amendment 1, our proposed language is in Section 203(2)A that reads, "The county executive may appoint interim officers to serve as any departmental director, as inspector general, or in any position outlined in Article 5 of this charter without confirmation. An interim appointment may continue beyond 120 days by extension or by reappointment, or another person may be successfully appointed to the same position on an interim basis only if confirmed by council." So in other words, if that were to happen, God forbid, a sheriff were to leave, you would have an interim appointment for the remainder of that 4-year term that the sheriff was initially appointed to. And that way you maintain that 4-year clock, if you will, until the 1 year into the county executive's term.
Well,
so these two provisions complement each other.
Yeah, and then I believe in the council president's issue has always been with interim appointments is liability and direction as an interim officer versus.
And diminishing the power of council.
Right, so.
The one thing for council to consider as you deliberate over these amendments is, and we had that issue with the appointment of the internal auditor, is it's different when somebody's running for office, you're running for a judgeship, you may run for an unexpired term, you're trying to get your name out so that people recognize you so that you can run again. A lot of these positions, if you have a police chief in a city and you're having them resign their position to come serve as the sheriff, and you're telling them you have a year left or you have a 2-year left, it can pose complications in terms of how you do the appointments because, you're serving for that duration. So it's just something to keep in mind as to the difficulty of filling that position. I'm not saying any way is better than the other, but it's just think of being able to attract candidates for those positions if they're too short.
Okay, all right. Very good. Any other discussion? Any comments from the CRC? No. Okay, I'll tell you what, just because of the time, I don't want us to get into an item and find that we need more time than we have here today. We will bring this item up. This item we will bring up tomorrow. We'll put this on the agenda for action tomorrow. Item 9 will move till Thursday. Are there any other? Let me look at my agenda for this meeting, just so I'm clear. I threw mine out, so I'll share it with Mr. Schron. Is there any miscellaneous business before the committee? No, and I didn't ask at the beginning of the meeting, so I'll consolidate it now. Any public comment?
No one has signed in to speak.
Okay, very good. So tomorrow we will meet at 1 p.m. In this chamber. We're adjourned till 1 p.m. tomorrow.